welcome to the Ellis Talker Show. I'm DV LeBron. Today, my very special guest is Mr. Tanawah Downing, who is a Naval Special Operations vet and a civil rights advocate. How you doing, sir?
I'm doing great. Thank you so much for having me.
Like I told you, I love having my brothers and sisters in arms that are doing different things to help society. I'm really glad you came on the show.
Yeah, again, thank you so much for having me. It's an honor to serve the people of the United States. I've been doing it ever since I first went out into the workforce, and I'll faithfully continue to serve this country and the people of the United States until the day God calls me home. Some of the things our government's doing is absolutely harming our people, and now I have an obligation to step up and fix the things I did in my ignorance. So again, thank you so much for having me.
Let's talk about how you got there. So you were in the military. Can you tell me a little bio, and then we'll go into how you led into the work that you do now?
So I served 8 years in special operations for the Navy. I did a lot of incredible work there. And I joined about a week after I turned 17. My whole life has been in service to the country. And when I separated, at that point in time, I already had my first master's degree. I had a master's in forensics at that point, went on, got another master's in substantive law, and then a third in information security. And so immediately after I separated, I went to work for an intelligence agency for a couple of years. It wasn't really a good fit for me, a little bit too intrusive in my life. So I went to work then for Department of Energy. I spent a couple of years working for a multipurpose lab in Washington State, Pacific Northwest National Laboratory, where I was the International Interdiction Program Manager primarily for the Middle East. I was doing systems that were designed to identify the existence of illicit materials, chemical, biological, radiological materials that were coming from the Middle East bound for the United States on containers, shipping containers. And then I decided to go off on my own. I started my own company in engineering firm where we specialized in national security technology design. 2013, we were the 13th fastest growing company in Washington State. The following year, we were the 22nd National Emergency Small Business. But I came to understand that national security is simply code word for domestic terrorism. You don't protect the government from the people, you protect the people from the government. I've been on the wrong side, and I bought into this notion of national security after the events of September 11th. And I think that a lot of America did as well. But we decided we were going to compromise many of our core values in the name of this protection, national security. That wasn't right, because the very things that we fight for overseas, the very things that make America worth fighting for, we chose to compromise in the name of protection. We need to understand that we can't do that, because if what we preach overseas is inconsistent with what we compromise here at home, then either America's not worth fighting for, or we need to reclaim that.
So what was the turning point, Tanawah? What was the, because for me, like one of the things that got me was when I was in Iraq and I realized something. Now, I love my country and I love the people that I served with. It was an honor to be with them.
Yeah.
But I did notice that there was a whole lot of money there. There was
Yeah.
a whole lot of money in that whole thing. And there was a lot of people making some big money off of it. And when I was able to conceptualize that, it really blew my mind. I came because I went raw after September 11th. I went raw.
Yeah.
And I came back there's something going on here. This is a lot bigger than raw. So
Yeah.
what was your turning moment?
Mine was the divorce, right? Back in 2016, 2015, I was making around 870,000 a year. I made a lot of money off of the things I did and the solutions I built. But what happened was that I went through a divorce. It was an extremely painful divorce. One that I didn't want, really didn't understand what was going on. But it was during that time that I started suffering myself in a way that I had never suffered before. And it was there that I started to see people that didn't exist before. Not because they weren't real, but because I didn't have the right perspective to be able to understand what they were going through, what they were experiencing themselves. Sometimes in order to help others, you got to suffer alongside them. And that's just God's way of preparing us. I couldn't understand what the homeless man was going through. I thought that he was lazy. And in all reality, I didn't understand that he has 90,000 limitations that's placed upon him because of a system that's chosen to oppress him rather than help him. I couldn't understand that the prostitute was going through a trauma that was a result of people not caring about what she's been through because of the hurt that's happened to her over her lifetime. These were people that did not exist to me before because I didn't have the right perspective. So as I was starting to become aware of these people that were suffering in ways that shouldn't have been because of the principles that I've come to understand, the principles that I believed in, I didn't really have a choice. I had to do something about it. So we all have an experience, a reality, but that reality is based upon our experience. So if I were to say to you that there's injustice in the world, you couldn't understand me unless you've experienced it. If I were to say to you that there's racism in the world, you couldn't understand me unless you experienced it. That's why two people could be standing side by side each other and yet have vastly different perspectives on what's real and what's not. Because we have to share in the experience in order to come to understand what it is that they're going through. And in doing so, we're able to help them in ways that we would not be able to otherwise, because you don't fight for something that you don't believe in. So what for me, what happened was I came to realize that what I believed in here in America, it wasn't real, right? It wasn't real because I bought into the principles of America that we have the greatest criminal justice system, that innocence doesn't suffer here, that you are innocent until proven guilty, that you have a fair shake in this process. And I came to understand that it wasn't real. And so for me, that was the moment that I had to come back to what I first loved, because I spent so many years fighting for money, making money, and that was my focus and my passion. And I came to understand that that was never what I was supposed to be doing. And about 9 years ago, I made the decision that I was going to go back into litigation full time. I was educated in it. I'm not an attorney. Attorneys go through what's known as adjudicative law. They learn about the adjudication process. So they learn how to make a person into a criminal. That's what an attorney does. They learn about ordinances, statutes, customs, judgment rules, all these laws that remove freedom, because that's what they're in the business of, is removing freedom. Now, on the other hand, an advocate is one that speaks on behalf of others. I went through substantive law, not adjective law. I learned about all the laws that restore freedom and set them free. And that's why the work that I'm doing is focused on these individuals and making sure that they get the things that were promised to them by the birthright, the things that are given to us by the Constitution of the United States. And so I'm in the business of restoring freedom. I speak on behalf of others in a legal matter. That's what an advocate does. Whereas an attorney is in the business of enslaving and imprisoning people, because that's what they're in the business of. They're in the business of making a person into a criminal.
So
Now,
what? I'm sorry to interrupt. So
yeah,
when you have as far as an attorney, or and I'm just trying to understand how you're putting it. So an attorney is, they work within the system that is there, and you're saying that the system is not right, and you work outside the system to make it right.
yeah.
Am I
So,
getting it? Am I
yeah,
getting
yeah,
it?
the attorney's handbook is known as the corpus secundum, right? So, in the attorney's handbook, what it says that an attorney is an administrative officer of the court. Now, a lot of people are under the impression that the attorney works for you, that they're there for your best interest, but that's not true. According to the attorney's handbook, they are there to advance the interests of the court. A first duty to them is to protect the judicial machinery. Now, to understand what an administrative officer of the court is, you got to understand what administrative law is. To look at the three branches of government, you have the legislative, executive, and judicial. The legislative branch, according to Clause 1, Article 1, is all legislative power is vested in Congress of the United States. So legislative power is all power to deal with law. So make law, amend law, destroy law, that's all vested in the legislative branch. All law and power to deal with law is vested in them, the Congress of the United States. Now, the second branch of government is known as the executive branch, and they're there to enforce the laws, right? They don't make law, they make orders, executive orders. Now, orders don't affect the people because the president of the United States can't order the people because he's a servant to the people. So he doesn't create law, he creates orders, but orders only affect those that can be ordered. So people within the executive branch are the ones that are affected by the orders, okay?
Mm-hmm.
Now, again, no right to create law, and I'll come back in a moment, but we saw this in a ruling on June 12th called the Chevron ruling, where the United States Supreme Court technically overruled the ability for the legislative branch or the executive branch to create legislation. You see, what was happening with Chevron was through what they called their ambiguity. If they didn't have clarity in the law, then they would provide clarity through what they called their policy. And then they would direct their agents, or they would order their agents to go out and enforce that policy, right? But what that meant was that the executive branch was able to amend the law through their policy and then go out and enforce that amendment. They have no authority whatsoever to amend the law because all legislative power is vested in Congress of the United States.
Making law, a lot of that, and I'm sorry to interrupt, guys,
Yeah.
you're on fire. And this particular subject is something that I'm coming new to it. They were redefining law, they were enforcing these redefinitions and expanding it, and the court said, knock it off, you're not supposed to do that. It was huge.
Exactly.
It's a monumental ruling that people had no idea about. And how has that affected has that trickled down in affecting the whole system yet, or it's still, as you argue, it'll start unraveling that administrative type state?
Yeah, that's a great question. And let me go ahead and tell you how what I'm doing interacts with that ruling.
Mm-hmm.
So what I'm trying to do is I'm trying to place the Constitution of the United States of America back in its rightful foundation. Because what's happened is that the executive branch was under the impression that they could create law through their policy. And they were going out and amending the law and then going out and enforcing it in violation of the Constitution of the United States of America. A great example is that the indictment by a grand jury that is required by Clause 1 of Amendment 5 to the United States Constitution. This is the heart of the litigation that I'm dealing with, right? Clause 1 of Amendment 5 says, no person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury. So that's clear. You got to have an indictment by a grand jury before arresting someone and holding them over for an infamous crime. Now, an infamous crime is any crime punishable by more than 1 year imprisonment in a penitentiary. So every felony is an infamous crime. Most gross misdemeanors are also infamous crimes because it's not the amount of time that you get sentenced to, but the amount of time you can be sentenced to. And if you can be sentenced to more than 1 year, that is an infamous crime. The prosecutor is the highest law enforcement officer within the county. It's up to them to determine which charging instrument they're going to use, whether it's an indictment, whether it's a presentment, or whether it's information. Now, according to law, Title 18.555, information can only be used as the charging instrument for non-infamous crimes, for misdemeanors. And yet there's 37 states across the country right now today that permit their prosecuting attorneys to charge by information or indictment by their discretion. And as a result, they rewrote the law that directly amended the Constitution of the United States. Now, our litigation is the primary respondent is the state of Washington. Because again, Clause 1 of Amendment 5 says, no person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury. However, Article 1, Section 26 of the Washington State's Constitution says, no grand jury shall be drawn or summoned in any county. So we have an inferior provision in an inferior state constitution that functions directly to the contrary of the United States Constitution. And now we got a supremacy issue. And so now we have to bring in what's called preemption to determine which law is supreme. Obviously, the state of Washington's law is not going to be supreme because it's in direct conflict with the Constitution of the United States of America. But what that means is that in the history of the state of Washington, they have never convicted a person legally and lawfully consistent with the procedures and processes established and codified in the Constitution of the United States of America. And that's a pretty big deal. When I first started this litigation, I didn't realize the magnitude of this because I thought that it was localized. I thought it was the state of Washington, only that. So when we went into litigation against the state of Washington, what we came to find out was that there are 13 states across the country that do not conduct a grand jury at all, including the state of Washington, including the state of Pennsylvania, including the state of Connecticut, the state of Oklahoma, Michigan. These are states that are acting in direct, willful defiance of the procedures and processes codified in the Constitution for the adjudication of crimes. Wow. Those are states that every single person that they have convicted are all unconstitutional because those convictions derive from an unconstitutional act committed by a state. If the arrest is unconstitutional because you did not have the proper documentation in accordance with the Constitution to perform that arrest, then that means everything that derives from it must also be unconstitutional because it is all tainted by the illegality of the way in which it was obtained. You cannot have a constitutional conviction derived from an unconstitutional arrest. Now, that's just the low-hanging fruit. But that means that right now today, there are more than 700,000 people currently imprisoned across America on direct facial constitutional violations, meaning that their convictions are void, wholly without force or effect because the states did not have the proper authority to be able to perform the arrest. Therefore, they do not have the proper authority to be able to take them through an adjudication process. And that means that their conviction is void, completely void. Wow. So of the 2.9 million people currently imprisoned, 700,000 of them are there illegally and unconstitutionally. And what I'm trying to say to America is that when we look at China and Korea, and we call them uncivilized because they take their own people and put them into abusive and oppressive conditions so they make t-shirts and sweatshirts for 30 cents an hour. And yet we do the exact same thing, only we call it justice. That's not justice. That's slavery. And it originates from the 13th Amendment, the very amendment of the United States Constitution that was designed to abolish slavery. It did nothing of the sort. Not only does it permit slavery, but it codified the legality of it within our foundational law. Because what the 13th Amendment says, it does not say you cannot have slavery. What it says As it says, neither slavery nor involuntary servitude shall exist except as punishment for crime. And the moment you say accept, it means that you can't have slavery. But we call it justice here in America. So we simply took something, retitled it something different, called it, changed it from a private institution to a public institution, and then told America it doesn't exist. But it absolutely does. And that's what's led to mass incarceration and the 800% increase in the prison population in 30 years. That's why America has 16 times more prisoners than the next closest industrialized nation. That's why we have 5% of the world's human population, but 26% of the world's prison population, is because we enslave our people and force them into for-profit businesses for the direct benefit of the state, and then we call it justice. There's a much better way to treat our brothers and sisters than to enslave them and force them into involuntary servitude. The issue of morality is not a matter of punishment. It's a matter of public health. And it's time for the people of the United States to understand that what we're doing is wrong and it's absolutely destroying our country. And so I'm here to fight for those people and make sure that we can heal the trauma that's been inflicted upon them by an institution and a government that had no authority whatsoever to do things that they're doing. Our government was instituted to preserve and protect the freedom of the people, not to enslave them. So by the breach of the terms of the contract, the Constitution of the United States, by breaching that, we now have the ability to be able to restore the freedom of these people, get them into a place where we can heal them from the traumas that been inflicted upon them, so we can actually eliminate the monsters that's been created by a system by healing the people that have been deprived of the very protections that this government was instituted to protect.
So the first thing I want to ask you on this, because I got a bunch of questions right now. The first one was, why are they not doing a grand? Is there like a specific reason they're not doing a grand jury? What is is it a malicious thing, or is it just, oh, we don't want to do that? What is it?
So the purpose of the grand jury is to provide a neutral, unbiased decision maker to review the state's accusations. A grand jury is 16 to 23 people, and what they do is they are there to review the state's case to determine or to place a check on prosecutorial and judicial power. Absent the grand jury, what they do is they use information. And what the information is that an officer, right? Someone calls up the police and says something happened to me. And that officer then takes that information, reduces it to writing in the form of an affidavit. And then they submit it to a judge. And they say to the judge, please hold this person over. That judge then determines whether or not there is sufficient probable cause to assume that a crime has been committed. It's up to the judge. But unfortunately, that judge works for the very same entity that the officer works for, that the prosecutor works for. They all work for the state. And the state is now opposing party to this individual. So there is no check. There is no neutral, unbiased decision maker to review the state's case. And that's why they say that you can indict a ham sandwich, is because the purpose of the grand jury is to protect the accused from hasty or malicious charges by an overzealous prosecutor or judge. Without an indictment, without a grand jury, without a neutral, unbiased decision maker that's not attached to the state, there's no one to review the state's accusations. This sets up what is called a trial by affidavit. Now, at common law, an affidavit is considered truth. And in fact, that affidavit is being submitted by the officer as though it is truth, because they say the following information is truthful, factual, and correct. But the problem is that this officer was rarely ever a witness to the issue, right? They're simply taking information from someone else and they're submitting to the judge through their oath and saying, all of this is correct by my oath. Judge, please make this arrest. And that judge accepts that as factual. Now, this sets up what is known as an irrebuttable presumption of guilt. Now, we know that any accusation unrebutted is truth. If you don't rebut an accusation, then that is truth. Now, when you prevent the accused from being present to be able to confront those accusations, because either one, these grand juries, 99% of them that are conducted, they don't permit the accused to be present, which is an intentional skewing of that disposition by removing and preventing the accused from being able to confront those hearsay accusations that are against them. But when you have information, there is no request to the accused to give them an opportunity to be able to confront those accusations. And now that sets up an irrebuttable presumption of guilt, which is the presumption that you are guilty based upon the mere fact of being charged with a crime. So now you're being deprived of liberty. That judge makes a determination, yes, this information, it looks good to me, and he orders the arrest against you. Doesn't give you the opportunity to tell your side of the story or rebut that accusation, the hearsay evidence that's against you. And now you're being arrested and you're being deprived of certain liberties that were supposed to be protected, right? So you're being taken to jail. You don't have the ability to earn money and take care of your family. All these things were supposed to be protected until you are found guilty. Now, this is what's known as a pretrial investigation or investigative detainment. So they're detaining you without giving you the due process to find you guilty of a crime. They do this because that sets up a certain amount of pressure, right? Where the prosecutor can overcharge you, where they can threaten you, they can intimidate you, they can put you in this place so that you're more malleable to accepting a plea bargain. And that's why 98% of all convictions here in America come by way of plea bargain, because of the situation that they've set up. So an irrebuttable presumption of guilt, what happens is that there's a shift in the burden of proof. Normally, what we expect the system to do is that the prosecutor, the state, is responsible for proving that you're guilty beyond a reasonable doubt. But in an irrebuttable presumption of guilt, where you are presumed guilty based upon the mere fact of being charged with a crime, now the defendant has to go out and collect evidence to prove that they're innocent, which is a shift in the burden of proof. It's no longer a prosecutor that has to prove that you're guilty. Now it's you having to prove that you're innocent, and that is a shift known as guilty until proven innocent, not innocent until proven guilty. And according to Blackstone, this particular breakdown of due process, it occurs when there's a focus on speed and efficiency as opposed to established procedural processes. Blackstone wrote about this. This is well known. This has been happening for thousands of years by these systems. And now we have a situation where there's absolutely a breakdown of due process because the system only cares about how many people can we push through the system as opposed to following the established procedures and processes that are in place to protect the individual liberties of people by limiting the powers of government.
Let me push back on you a little bit.
Okay?
If there's one thing that I understand in my career after the military is that there are some very evil people in this world, and
Yeah.
some of them should never see the outside of the fence. I'm trying to figure out whether it's something in general you do understand that there are some evil people and that they don't need to leave the fence. Your problem is how we're doing it, that we need to do it according to the Constitution.
So just so we're clear, I'm not an abolitionist by any stretch. I know that there are people that are dangerous to society. I know that there are people that need to be protected from society. But the problem that I have is that you cannot break the law in order to enforce the law. I'm not saying that we need to let dangerous people go free. But what I am saying is that even the top criminologists in the world say that only about 4% of our prison population are a danger to society. We know that 78% of people in prison never hurt anyone but themselves, drug-related offenses. We know that another 15% are property-related crimes, right? Crimes that don't even have a victim. That's aberrant behavior. That's not dangerous behavior. And aberrant behavior is dealt with much differently than dangerous behavior. So I'm not saying that we need to let dangerous people go free, but I'm saying we need to take a real look at this system and we need to decide who is a danger, because most of the criminologists across the world will agree that only about 4% of the population in prison are actually a danger to society. But even those people have got convictions that are not constitutional because the states didn't follow the rules. So I'm not saying let them go free, but I'm saying you better figure out who is a danger to society, right? Because you didn't follow the rules, and you didn't follow the rules because you wanted to make money. You wanted to put people in prison so that you can make money off them, so that you can enslave them in these institutions that are for the direct benefit of the state. That is what I'm saying. But even the unconstitutional convictions, we got to address them, and if they're unconstitutional. But what we can do is we can switch them from a criminal incapacitation into a civil incapacitation, and we can put them into a place where we can actually heal them, where we focus on the trauma and the healing. Because I'll tell you, even the most dangerous and violent people in our society, they themselves were victims of horrible crimes committed against them as children. We do have, and there are nations that we can look at as an example. Sweden is a great example. Sweden is getting ready to shut down its final prison because they chose a restorative-based justice system as opposed to a punitive-based justice system. They chose to heal their people as opposed to hurt them. And we are the only nation in the world that went a different direction. We went punitive as opposed to restorative. And like I said, there's examples we can look at. Sweden.
I'm a believer in restorative justice and trying to get away from, for instance, there's a veterans court in the county that I live in, and I'm part of mentoring that court for vets so they could get a second chance. They go through this program, they go through a year, 2 years of this thing, and once they're done, their record is gone. They get another chance, and that is something I truly and honestly believe in. And I believe that we need to show these guys a trade, show them something so that they don't get out and come back on our tax dollars. But I want to touch on something else because the system that you were addressing on the federal side.
Yeah.
They don't have to actually prove that you moved 10 pounds of this to there. They just have to prove that you were there. And these conspiracy and RICO charges that they started using RICO charges, things that they were using on mafia, they started using on the average Crip on the
Right.
street. And so, what I've seen in my time in my chosen profession is that some people, they got grouped up in these things. And I'm not saying that they were innocent per se, but I'm saying that they got into a big old dragnet, and then they had a government with unlimited money
Yeah.
that told you if you went to court, we're going to give you 20 some odd years.
Right.
If you don't go to court, you might get out in 8. And that's something that I've seen throughout my career. So when you talked about the system definitely needing some change, I agree with it. Now,
Yeah.
what are you working on now? This case that you've been working on. Talk to me about that because I'm running out of time.
Yeah. There's robbery and extortion are extremely close together on the criminal spectrum. Robbery is to formulate a contract through illegal means with the threat of immediate bodily harm, right? So if I have the power to bear arms and I go and buy a gun, I point it to you and I say, give me your money or I will shoot you. What we're doing is we're formulating a contract for your money, but it's not being done through your volition. You're not wanting me to have your money because I'm such a great guy. You're giving me your money as a result of fear or duress that I inflict upon you because of the abuse of my power for immediate bodily harm. That's robbery. You'll go to prison for it. Extortion, on the other hand, is to formulate a contract through illegal means with the threat of future harm. So if I'm a prosecutor, I have certain powers. Well, I have powers to send you to prison or give you charges. If I abuse my powers the same way as a robber and I say, if you don't plead guilty, I'm going to send you to prison for 20 years. What I'm doing is I'm abusing my powers, formulate a contract, not through your volition, but as a result of the fear or duress that I inflict upon you through the abuse of my powers. And now you've entered into that contract. But that contract is for future harm. And so that's extortion. You can never formulate a contract with the threat of harm, of future harm, through the abuse of your powers. If you use duress to formulate a contract, that contract is void, wholly without force or effect. Now, the constitutional provision that attaches to this is the self-incrimination clause of the Fifth Amendment. Because what it says, no person shall be compelled in any criminal case to act as a witness against themselves. Now, in this context, compelled, according to Blacks, means to bring about through the use of threats or intimidation. So if you use threats or intimidation to get a person to act as a witness against themselves, you very clearly violated the Fifth Amendment's self-incrimination clause. The problem is, down at the bottom of a plea bargain, it says, I did certain things, and you sign it, meaning that you are acting as a witness against yourself. And in fact, you are the only witness. And the way that they get you to do it is through the use of threats or intimidation. It is absolutely a violation of the self-incrimination clause, the Fifth Amendment self-incrimination clause. That is part of what we're litigating. But we're doing it through the use of the indictment by a grand jury issue. Because again, 700,000 people currently in prison without an indictment by a grand jury. And then you have, of the 2.9 million people, you have 2.8 million of them that were not present in the grand jury to confront the accusation against them. We're going around the country and we're serving all the state attorney generals and all the state Supreme Courts with notices that their prosecutors are committing a crime when they either, one, deny the accused the right to be present to confront the accusation against them. That is called conspiracy to obstruct justice. Now, that means that when the prosecutor conspires by and between the accuser to deny the accused the right to be present, they commit that crime. Now, conspiracy to obstruct justice says when two or more persons conspire for the purpose of preventing any party in any cause from participating in said cause, commits that crime. Again, the purpose of the grand jury is to protect the accused from hasty or malicious charges by the prosecutor. So when the prosecutor denies the accused the right to be present to benefit from the very proceeding that exists for their protection from the prosecutor, it doesn't take a rocket scientist to understand we got a pretty big problem, right? The prosecutor has no authority to be able to deny the accused the right to be present to benefit from that proceeding because Title 42, subsection 1981 of the Civil Rights Act says that all persons within the jurisdiction of the United States shall have fair and equal benefits of all laws and all proceedings. The Fifth Amendment is a law protected by 1981. The grand jury is a proceeding created by the Fifth Amendment. Therefore, it's protected by 1981. And as a result, when the prosecutor denies the accused the right to be present to benefit from that proceeding, that is a violation of 1981. And the enforcement statute that derives from that is conspiracy to obstruct justice. So we're providing notice to all of these state attorney generals, all the state Supreme Courts, letting them know that crimes are being committed by their agents. The attorney general is in charge of all the prosecutors. The Supreme Courts are all in charge of all the judges. And so by providing notice to the highest executive and highest judicial officers in these states, we're giving them an opportunity to correct the unlawful acts of their agents. Our goal is to get to the Supreme Court. and to make them correct this behavior across the board, because they're actually responsible for all these acts of deprivation across the whole country. They are the ones that have to address it. And we don't have time to go into the reason why, but they are absolutely responsible for it, from a number of rulings that they made starting in 1833 all the way to 1887, where they fundamentally removed the guarantees and protections of the Constitution of the United States, put into place what they called case law, which is not law, because judges don't create law. They may not legislate from the bench. They overstep the separation of powers, legislate from the bench. They amended the Constitution in an other than lawful manner. And in doing so, what they put into place was absolutely unconstitutional. These states then created laws that permitted their agents to violate the Constitution. And once again, if you want to know how to change or amend the Constitution of the United States, you go to Special Amendment Procedure of Article 5. It tells you exactly how to do it, and it has nothing to do with the executive branch. So when the Supreme Court of the United States created a ruling, erroneously called it law, amended the Constitution in other than lawful manner, then what they produced was unconstitutional. And it's not unconstitutional from the moment deemed such, but rather from the moment it was created, as it was never created at all, because that's how you deal with the unconstitutionality of statute. So when that happened, the Supreme Court of the United States, they introduced fraud into the system, and by that fraud, they directed all the states within its purview, all the courts within the nation, to act unconstitutionally. And until they correct their despicable rulings from their predecessors that we have to call honorable, until they do that, all of these courts across the country are acting unconstitutionally, because that court, the highest court in land, has directed them to do such. So we're dealing with the highest court in land, and we're there. We've already been through all the states. We've already been through all the federal circuit. We're at the Supreme Court on a jurisdictional error. And we're just waiting for the right time to push it into that court, demand and invoke what's called Article 3, an original jurisdiction of that court, demanding that they address these acts. And we can't do that until we provide notice to all the states, all the state agents, and directing them and giving them opportunity to be able to correct these actions, which they're choosing not to. And that's understood. But that's what we're out here doing right now, is we're notifying all the states, all the state agents, by notifying the highest executive judicial officer in the state. This is a mass notification through notifying the highest court in land of these crimes.
This is big. This is so big. And I'm over here like I'm processing what you're telling me. And it's just so big for me, but it's so interesting. I'm like sitting here just taking this all in, because there are things that I don't have the expertise to know that something's wrong, but I have the common sense to know that something's not right. I'm sure that you've paid a personal cost for this battle. And I thank you for stepping up, because you see something and you're deep in it and you want to correct it. That is a wonderful thing, because there are a lot of people in prisons in America, a lot of people, and some of them should never see the light of day, and some of them don't need to be there. And if it wasn't for somebody in the wilderness saying, hey, something is wrong, these people will probably get no justice. I got to close out, but I give my guests always the last word. I'm going to give you the last word to go ahead and talk to my viewers.
Okay. So 9 years ago, I made the decision I was going to do this, whether there was money or not. I do this for free because these people in prison, they don't have money. And I can't expect something from them that they don't have. I operate only on donation only. That's not what the point I'm getting at here. The point I'm getting at is that this has been extremely difficult. Just like you said, this cost me everything. This cost me my house, my career, my wife, my kids. It cost me everything to do this. And I would do it again, because what I do have is that my kids, at some point in time, when I realized that what I was doing was wrong and that I was leading my own children in the wrong direction. So for me, this has been an opportunity to be able to become the man that I need to be as for my children, to give them the direction that they need to have. Because if my son is going to be like me, then I must be the type of man that I would approve for him. So if I'm going to be proud of the man that he becomes, I must be proud of the man that he emulates. So this was my responsibility to step up for him and show him, son, this is what you do. When you encounter people that are suffering, it's our job as a man, as a husband, as a father, it's our job to do something about it. And for my daughters, I have an equal task, and that's it. My daughters can marry someone just like me. So if I'm going to be proud and happy and content with the men that they choose to give their hearts to, I must be the type of man that I prove for them. And this has been me setting an example for them, even in my absence, so that they can grow up and have an example of how they're supposed to be. For the people of the United States, this is a huge task, but I think that this is one that we can all rally behind. What is it that we believe in? Do we believe in judges that are able to act in an arbitrary and capricious manner, or do we believe in the Constitution of the United States? Do we believe in its supremacy and the words that it says? Can we rely upon it and look to it for lives and our sustenance and have faith in it because of the words that it says? That's what's going to create stability for a nation. The chaos that we have is a result of us failing to follow the one thing that was instituted, put into place, that was going to guide our country. And so if we turn back to it, we remember what our faith is, and we rely upon it, we follow it, I believe that much of the chaos that we have in the country right now, I believe that it will be resolved. And so all that I'm trying to do is I'm trying to ask the people, what is it that you believe in? Because if we can't believe in that Constitution and its supremacy and its power, then I'm afraid we've already lost our country. Because the only thing that makes America America is American laws, and it starts with that Constitution of the United States. And if we cannot believe in it and its power and supremacy, then I'm afraid that we lost the United States of America. And I don't want to live in a world where America doesn't exist. So I'm simply asking the people of the United States to decide, do we believe in it, or do we believe in judge-made rulings? Do we believe in its power and its words, or do we believe in the words that judges say? And once we figure out what we believe in, then we know the path we're going to have to take to remedy this situation. And I'm saying today, let's make the right decision, because right will always produce right. We are in the wrong place today because we made the wrong decision, 60 years ago. I want to make the right decision today. I don't know how that looks. I don't know how, but I do know that if we make the right decision, we will reach the right outcome. And so that's what I'm hoping to achieve through all this litigation. Is I want to get us heading in a different direction, because clearly the trajectory we're on today is not heading in the right direction, because we're not making the right decision on the issue itself. So thank you so much. God bless, brother.
Tanawah, wow, you blew my mind, man.